That's recording now. Yes. Okay, so this is Laws 12059 Conveyancing, and this is the tutorial covering topic 4, which is the second instalment, if you like, on seller disclosures. And this idea of the obligations of the seller to disclose it. Just, when I was revising or reviewing the material in anticipation of today's class, what stands out in truth is this tension between what the seller wants or what the vendor wants and what the buyer wants. And yes, it's underpinned by a contract of sale. And the process that we are moving through is what we refer to as a land transaction, underpinned by the contract of sale, but also affected by and regulated by a swathe of legislation, not only the primary property law statutes in Queensland, as we now quite familiar with, the Property Law Act 1974 and the Land Title Act 1994, the Torrens Act, but also a swathe of other pieces of state-based legislation, and also to some extent, in some cases, Commonwealth legislation, but mostly state-based legislation, that is about trying to control and direct and govern how you can do, how owners and those that are going to be owners of land or lots, as it's referred to in Queensland, what they can and can't do with their property. And also trying to strike a balance between the interests of the private owner on the one hand and other interests that we might generically refer to as public interests or social interests or communal interests on the other. One of the ideas that pops up in today's class, and I hope we can get a little bit of debate around this, is the tension, if you like, or the connection between the rights of the private landowner to do what they reasonably want to do with their privately owned land. I put private in inverted commas. And, for example, something like preserving cultural heritage or other forms of heritage. But cultural heritage becomes quite significant and poignant, actually, when one thinks about, for example, Indigenous peoples. Even though when we, in this topic 4, for example, a substantial chunk of the topic is looking at the BCCM Act, the Body Corporate and Community Management Act 1997, which has been amended several times and is also subject to extensive review by the Property Law Review 2014. We don't tend to think of the circumstances of the application of that Act touching upon, for example, matters of Indigenous culture, because we tend to think about that, the application of that in the context of more built-up environments. And in Queensland, we tend to think more of the Gold Coast, the Sunshine Coast, southeast Queensland, possibly further up into the developing areas of Queensland and so on and so forth. But, of course, there are other types of heritage that can be protected as well. But the other point that comes across, and we'll get to this when we look at the question that has asked you to think about the Mervac case, is that the seller, particularly where we're looking at, say, the situation of proposed lots as opposed to existing lots, that is, we're looking at, in practical terms, I mean, that's the legal language of the legislation and of the governing law in this area. But if we talk in practical terms, we're basically looking at a property development scenario. And the seller at that point is not a private person, sometimes generally not a private person, but particularly in that sense, not a private person. The property developer is very often a corporation who want to sell multiple lots or proposed lots, and they're selling off the plan, if you like. And prospective buyers are buying off the plan. And then you get into wrangles as the development, they're selling the lots, proposed lots off the plan, but they're doing what's referred to in the industry as progressive release. And progressive release, even when all the amenity and facility and circumstances of the development, which has actually attracted the buyers and purchasers originally anyway, have not been completed. It's a staged development. And then we can talk about, well, you know, what sort of things are important there? Well, if there's missing stairwells or missing things of that nature, well, that's pretty critical. If it's something like a missing tennis court or a swimming pool, it's less critical, arguably. But the buyer may well be buying because of that amenity. When you see arguments, like in the Mirvac case we'll get to momentarily, where prospective purchasers of proposed lots are concerned about the proximity of their privately owned lot to public land or the National Tennis Centre, because the noise may somehow, or somehow members of the public may somehow be going to intrude on their private space, and that we need to make sure we've got absolute security around this building to prevent that from happening, then that's the backdrop very often to what becomes the legal wrangles and the legal disputes that then get converted into legal language in terms of definitions and procedures under legislation. But let's not shy away from the reality here, what's really going on. Because I don't know, all of you are sitting in Queensland, is that right? Thumbs up if in Queensland.
Yeah, I'm in Queensland. Yeah.
I think Grant's not in Queensland.
I'm in New South Wales.
That's right. We've recently just had an unfolding saga in New South Wales that at first blush doesn't look like something that might touch seller disclosure issues or BCCM Act issues or the equivalent in New South Wales. But what we've had is we've had two politicians in New South Wales Parliament resign because of Independent Commission Against Corruption investigation findings. But they've resigned not because they've had the money in the money bag or in the lolly jar, which they have had, and been very happy to have it in there until it was identified publicly. But we also now discover that, for example, in New South Wales, in Newcastle actually, there was proposals to rip out rail lines and to reinsert transport infrastructure in the nature of light rail, and there's extensive light rail network just been opened on the Gold Coast. But guess what? In Newcastle, they were not going to put the light rail in the same place that the heavy rail was, and the argument that was publicly put forward at the time was, oh, well, we're locating it in an area that actually is more convenient to promote movement of people and whatever. But what has now been apparently revealed is that the location of the new light rail infrastructure was actually down a corridor of properties that were being under property development by a certain property developer, and guess who, or guess what, was involved in the property development aspect? Some of these individuals, both within state parliament in New South Wales and also within local government within that region. So property development is never too far away as an influencer in terms of some decisions that are taken, both with regard to sometimes changes to law and sometimes with regard to how law gets implemented along the way. And what stands behind that, of course, is the money. Show me your money. Show me the colour of your money. So, we're not here to investigate all of those tentacles and so on, but that stands as a backdrop behind what are some of the bigger issues. And within seller disclosure, what's really going on is this idea that buyers and purchasers have a right to know what affects what they're buying because they're consumers. And so there's this emphasis which comes out in some of the material and comes out in the case law of consumer protection. But guess what? Today, of course, we now also have federal comprehensive consumer protection legislation under the Competition and Consumer Act 2010. So again, we have to be mindful of that. That's referred to in the relevant chapter from today's discussions in the notes and so on. We can never today forget too much the impact of the federal competition legislation because it's touching a number of areas of law which previously it didn't get involved in. And then the other point that we must also just keep in the back of our minds as we progress through every topic in this course is the impact of e-technology on the conveyancing process and on conveyancing transactions. That is e-conveyancing. We've already seen this earlier in the course, but we need to keep reminding ourselves what is its impact in the context of this particular part of the course that we're thinking about, because it has an ongoing and a continuing impact. Has anyone got any thoughts they want to throw in just before we think about the problem questions for today?
We're touching on the subject of ethics again, except not in the context of the legal representative, in the context of the power makers.
Absolutely right.
Can't seem to get away.
Sorry, go.
Can't seem to get away from it.
No, can't get away from it, son. And the tragedy, I will name it as the tragedy of the commons. It's more famously named like that in other contexts, but in this context, I think it's not inappropriate to talk about the tragedy of the commons. Then the lack thereof, and we constantly get shown examples of people who hold power, people who hold positions of trust, who flagrantly breach the trust in the interests of self-interest and money and property accumulation in their own interest. And they couldn't really care about the consequences or about who's affected or whatever. They're happy to bend and manipulate the law, and plenty of examples in the case law, before our eyes, in current revelations variously, with regard to these sort of issues. So it's lurking there all the time. And truthfully, people, to be a robust lawyer and a practitioner in whatever area of law or practice or organisational life or professional life that one becomes involved in, there are challenges here. There are also very often in the course of one's professional life enormous temptations provided and offered up from time to time, depending on positions that one holds or whatever. But one needs to be very robust here to be holding the line, in terms of what one does as a professional advisor and the role that one plays, and secondly, to be holding to what is lawful and what is ethical. And in this area of seller disclosure and the getting the balance right between these competing and conflicting interests, not necessarily easy. Anyway, be that as it may, not a class on ethics, but as Grant points out, a backdrop to most of things that we end up exploring. Problem 7. Now, I've deliberately, and I've flagged that just in my opening remarks, Problem 7 takes us into the Wilson and Mervac case, which is a fairly recent Queensland decision, 2010. Maybe would anyone like to just open up, before we actually tackle the actual question, would anyone just like to sort of introduce us to the facts of what's going on in the Mervac case?
I'll have a shot. Basically, a federal magistrate or federal court judge moving into a new sort of off-the-plan or intending to move into an off-the-plan development had a requirement for closed-circuit television. Because of his status, he was potentially at more risk than potentially the ordinary person. And when Mervac changed the plan or the arrangements of how that would be, or the type of security that was going to be provided, they believed that, or the wife of the federal court judge believed that they would be materially prejudiced because they wanted that security and it was not as sort of to what they were expecting. And it seemed to be the underlying theme from the case seemed to be addressing more about sort of who is the reasonable person. Is it generally sort of what people would expect, or does it come down to sort of, the individual expectations?
Yeah. Are you saying that one of the parties was actually the wife of a federal court judge?
Correct. I think the claimant is the wife of the federal court judge, isn't she?
Well, it's interesting that, the claimant is Catherine Frances Wilson, and the Supreme Court judge in the case is Justice Margaret Wilson. Have the same surnames, and I'm not sure. Does it reveal?
Yeah, I'm sure the case does refer to her husband being the judge.
Does it? Good. Well spotted. Well spotted. She certainly, in one of her letters back to Mervac, indicates myself and my... so, for example, and I've got a copy of the judgment here in front of me, and you might just, for those of you who maybe haven't got it with you, just make a note of this. Paragraph 15 of the actual judgment. There's reference there to the applicant is talking about security. One of the issues come up, the security arrangements, and security is and was a very important consideration for my husband and myself. So reference there to the fact that the applicant is involving her husband, but the named applicant in the proceedings is actually the female, Catherine Frances Wilson. I didn't pick up on the fact that it was actually the applicant was the spouse of a federal court judge, but that I don't know what that explains necessarily in terms of the nature of the application that's being brought. But okay, that's fine up till there. That's fine, Grant. What was the main issue in Mervac? Does someone else want to? David, do you want to chime in there?
Sorry, I was just getting my my mute button off. Yeah, I think it was just the fact that there was a substantial difference in what he was expecting to be in place by the security system and to what was actually going to be in place at the time.
But why was there a concern about that? I mean, that's right. Factually, that's right. But why was there a concern about the security? Because the type of security which wasn't in place... I think
just because of...
And things like that, or what sort of security arrangements are we talking about?
I think it was a closed-circuit TV security system.
So the applicant is concerned about the lack of electronic surveillance.
Yes, that was from my understanding of the case, yeah.
Why is the applicant concerned about that?
I think that's because of his status and what was we were just talking about then with him being a judge and whatnot, and having those security concerns.
But security concerns in relation to what? Lisa, you got any thoughts on this?
Hi. When I read it, I thought that the
just turn your sound up a little bit, please.
Oh, okay. There you go. Is that better?
That's much better. Thank you.
Oh, good. I actually discussed the phrase material prejudice, and so whether them not having the closed circuit security system prejudiced them enough. It came down to the inaccuracy in the contract and whether they were prejudiced enough, and it was an objective test, but also a subjective test taking into the circumstances of the buyer.
Yeah,
and
that's the legal test. That's correct, and that's the legal language of the legislation of the relevant provision of the BCCM Act. But what was it that the applicant was actually concerned about? I mean, David's indicated that the concern was essentially about, CCTV, which I've reinterpreted. The judge doesn't actually say this, but that's about surveillance, right? Electronic surveillance system. But what were they concerned about? Why were they worried that this electronic surveillance system wasn't actually up and running?
Well, they were obviously concerned about their security for themselves and their property, and if they didn't have it, they probably couldn't move into the house.
What does that mean? What did you understand from the case in terms of security? What did they feel their life was threatened, or what do we mean by this security issue?
Oh, look, I'm not really sure, Michael.
That's all right. That's all right.
What exactly they were concerned about.
That's right. Anyone else?
I was just thinking that it was because they placed such a high need on security, and then that option was no longer available. Whether or not they felt threatened or not, but just the fact that they went into this with the understanding that that would be provided, and then it turned out it wasn't.
But in there, and I appreciate you may not have the case in front of you, but for example, again, I refer back to paragraph 15 of the judgment, and you can get a copy of the judgment from Ostley, okay? But you can look at paragraph 15. The applicant actually says, just listen to this, right? Security is and was very important consideration for my husband and myself, given our personal circumstances, and the proximity of the Farringford building, which is the building I think that they were proposing to occupy, to the State Tennis Centre and proposed public parklands. Why do you think they're so concerned about the proximity of the building to the tennis centre and public parklands?
Because there'd be a lot of public thoroughfare through that area.
Okay.
So there might be a greater risk.
What sort of risk do you think, Lisa? What? Grant? Lisa, Grant, whatever. Say again, sorry, Lisa.
I was going to say trespass or burglary.
Grant, any thoughts?
Yeah, I'll read in a little bit. It's really, I guess, I'm assuming that the tennis centre, you're going to have potential hooligans. They're in close proximity to a sporting event where you may have unruly behaviour.
Yes.
And for them, it was important to have the deterrent effect of CCTV. It was part of a broad concept of security that was promoted to them.
Of course, you necessarily have hooligans going to tennis matches and things like that, don't you? I suppose. You see, sorry, go on, yeah, Grant.
I was going to say, although further into the judgment, I think the court sort of concluded it was more the status as a federal magistrate, that the risk of disgruntled people who had, he may be sort of under threat, or his family may be under threat from disgruntled plaintiffs or defendants or people that were not happy with his decisions. That seemed to be more, I think, what the court read into it, although if you looked at the letter, it seemed to be more about the proximity to the tennis centre, which
I want to put it back to you people that, I mean, apart from the legality, which Lisa's directed us to, and that's important, we need to deal with the legality because it's the basis of the action. But of course, getting back to this material prejudice aspect of the statement of disclosure and the amended statement and so forth, whether that justifies walking away from the contract, which we'll get to in a moment. But surely, arguably, one can say, but it's a bit of a far-fetched argument, actually. One could say, quite within reason, that these things were held out to have been installed within a certain time frame. They weren't installed by a certain time frame, and you might argue that I've been misled, or things have been disclosed to me that weren't truthful because it hasn't occurred, or what. Even though we know as a matter of practicality, with a staged development of a property development, that there can be delays and there can be issues and a whole range of things that can cause the need for adjustment and so forth, and maybe further amendments to statements and whatever. But really, I think if one's going down the track to suggest that an occupant of these premises, and I'm not entirely sure as to how many lots there were in this development, but certainly one would have thought there'd be several. It just seems to me, a long bow to be suggesting that I've got a concern for my personal safety because I'm near a tennis centre and there are public parklands. I mean, surely the proposed purchasers were aware of the proximity to the tennis centre and the public parklands before they decided to move to this dwelling. And with all due respect, I don't know what sort of ultimate protection surveillance cameras can provide if people are quite committed on embarking on certain courses of action. But what the reason I'm focusing on teasing out this, if you like, is because it's really important not to get lost in the legalities, but to be aware of the factual matrix, and not even the factual matrix as it's presented through the legalities. But what's really going on here? What's the real issue? What are we really trying to seek to protect? What is the other party really trying to seek to oppose, and why? And how is the law being used as an instrument to achieve that end? We need to have a sense of that, as well as have a good grounding in understanding the legal process and what the law requires. But don't forget, people, that sometimes, as we, in my opening remarks indicated, law is used and is manipulated for particular ends in some situations. I'm not suggesting that that's necessarily happening here, but it is interesting. When private ownership of dwellings or of space pushes up against public space, for some reason it seems to heighten concern. I don't know why that is, but it seems to heighten concern. On the other hand, I'll just give you a little instance of a reverse situation, which again tends to emphasise, I think, self-interest. I took my daughter to a friend's house over the weekend, and they've just recently purchased a dwelling not too far from where I reside, and nice area and whatever. It's a house on freestanding dwelling on a plot of land, and it abuts a public school, a local, primary school. And guess what? There is no dividing fence between the schoolyard, which is actually like parkland, and the boundary end of the property that's owned by the parents of my daughter's friend. And I came in and I was invited into the home, and it was explained to me this and showed me this wonderful, parkland at the back. And I said, "Oh, where is the boundary line?" He said, "I don't see any fence." He said, "Oh, no, there's no fence. There's never been any fences in this area." I said, "Oh, that's interesting." I said, "So what's that behind?" "Oh, that's the public school." And I said, "That area, oh, that's the grounds of the public school." "Oh, I see. Where does your boundary, your property finish?" "Oh, it's marked by, we paint some dots on trees." I said, "Oh, that's interesting." He said, "Oh, yes." He said, "This is excellent because when school's out and during non-school time, that's all my backyard. Just extends all the way." And I said, "Oh, that's very interesting." See, you can take the issue about the connection or the abutment, if you like, when you use that phrase, between privately owned land and public space or publicly owned land in different ways. Because in that situation, those school grounds in this state and this equivalent law in Queensland is actually governed by enclosed lands legislation that actually doesn't permit any access, any ingress or egress from the property with penalty of action being taken by a public authority in trespass. Now that's very interesting, because how do you determine that we're a situation where the boundary is known to the parties but actually is not very clearly identified at all? Anyway, that's a separate issue. So we've got David, do you want to say something?
No.
Okay. So we've got a sort of a general idea of what's going on in the Mervac case. Let's now come back to the actual problem question. So the focus is on this idea of material prejudice. Explain what the Court of Appeal means when it says that interpreting the above phrase, that is this phrase of material prejudice within 2144B of the BCCM Act. By the way, just along the way, just be mindful of the fact that there's been amendments to this Act, and it's now, we've now got a fairly comprehensive review taking place where we've got 2 discussion papers that have come out, and one, if not both, making some specific reference to the BCCM Act and how it should be changed and adjusted or amended. So just be aware of that. So the question, or the problem question, then says, interpreting the above phrase requires a consideration of the personal circumstances of the buyer in what is otherwise a determination to be made objectively. What am I getting at there? Or what is the question getting at?
That although it's objective, there's also a subjective component, which means don't they have to take into consideration the personal circumstances of the buyer? And I think that security surveillance that works pretty well as a deterrent. So maybe that's what they had in mind.
How do we understand this relationship between the subjective and the objective, though? How does it work, basically? That's what I'm trying to get at. How does it work?
Well, the objective takes into account, I'll get off with the subjective, takes into account their personal circumstances. And objective is what, isn't that just a reasonable person test, objectively speaking?
Yeah, and how do we work out what the good old person on the Clapham Omnibus would do in this situation? David, Grant?
He determined what a reasonable person would do in the circumstances. Hang on. That's a
good lawyer's response, Lisa.
I was going to say.
Yeah, Grant?
The reasonable person is a person of similar circumstance. So if the reasonable person is a federal magistrate who is under threat or a higher sense of risk, then the reasonable person is somebody who is in a similar situation with a similar set of circumstances. So it's not just the anybody reasonable person test.
So what's the essential point of demarcation between the objective strategy of the provision and the subjective overlay of the circumstances of the individual involved?
Is an objective just meant to be factual? An objective determination is made on the facts. Subjective is made on, I guess, the judge's perception, feeling.
And are not the facts also subject to interpretation?
Of course they are.
What am I trying to get at here?
That judges have considerable leeway to put their personal opinion into their considerations?
Yes. Yes. I suppose I'm. That's probably the point. Look, this really goes, in my view, to the heart of what law is really about at the end of the day. It doesn't matter what area of law we're looking at, we find these sorts of formulations, these sorts of tests being inserted into the law, right? And a form of words is used that then get interpreted when disputes arise before courts, and when we get a decision from a superior court, we get a guiding judgment as to how we understand the language and the words and so on and so forth. Of course, what the law wants to say is that the way we interpret the application of this governing framework of legislation, in this case, to a factual situation is an objective process that requires steps of logic and steps of analysis. It's not just what we think, it's not just our opinion, but this is the process that necessarily must be followed, even though no two judges necessarily always agree with each other. But the process is objective, and we all understand that. So that's what the law desperately wants to say, and in the way that it's crafted and the way that it's framed and phrased, it often seeks to extol that. Then, on the other hand, we can say, but wait a minute, there will be situations where the individual circumstances of those involved or affected need to be considered. The subjective aspect of that needs to be a part of the process, but that doesn't overtake what is essentially essentially an objective process to determine the application of this framework to this set of facts to produce an outcome which is logical and which we will, commonsensical and we can agree on, even though another judge may actually come to a different outcome by following the same process. What's really going on here is this desperate need to convince ourselves that law is not about what we value and what is our personal position on something or on how we understand a set of facts, but that this is just, go through this objective process and apply this test and this will be the necessary outcome. The truth, of course, is that it's always a mixture of both, and that everyone that's involved in the process needs to understand that. Of course, we can't have a system that's just about, what did I think because I got out of that side of the bed this morning? I mean, that's a nonsense. We can't have that. But if we want to run away from the reality that how I'm interpreting this is a part of who I am and how I see these facts, which may not necessarily be exactly synonymous with my learned colleague or whatever, whether we're talking about two practitioners or two judges or whatever, if we don't own and recognise that, then we're shying away from the reality of how we actually need to analyse the situation, and we need to work between the objective and the subjective. The question, the critical point at the end of the day is how we get the balance right. Grant, you want a question?
When I was reading the case, what I found a little bit difficult, seemed very convoluted. It seemed to go into a whole lot of the subjective intent of the Wilsons, but I didn't see why that was necessary, because to me, black and white, I understand that if you're buying off the plan, you can have disclaimers saying, you know, up to a 5% variation in floor area or something like that between the balcony and the inside, and trivial things like that. But if you contract to buy a property with CCTV, and after entering that contract, the CCTV is withdrawn for whatever reason, even if it was withdrawn mistakenly, then that's just, to me, I just thought that was a straight out breach of contract. I didn't think it mattered whether it was important or trivial. I just thought it was just a straight out breach of contract.
Now, that's a good question, because if it just gets interpreted like that, then of course the party alleging the breach may well be able to say, well, now I want the remedy that breach of contract will provide, and it actually may mean that I want the contract to come to an end. Now, of course, in this type of scenario, the seller, who, as we know, in this case is a property developer, is going to fight tooth and nail to prevent such an outcome, because it could be a snowball effect. And the property developer, of course, is operating on the basis that people can't actually easily just pull out of the contracts willy-nilly. Okay, once they've committed themselves, even though this dwelling that they're, or this space that they're going to own is maybe the whole thing hasn't yet been finished, or whole complex hasn't been finished, then they have entered into a contract of purchase or contract of sale, and that they can't at all very easily withdraw from that. And determining what amounts to a breach of contract, is seen, there's certain hurdles that have to be climbed to get there. There are a number of these procedural mechanisms within legislation, and there's some remedies available if they're not complied with, including, withdrawal from a contract in some circumstances. But that's really, I think, what's going on here in terms of that idea of the breach of contract notion. But it's an interesting, good point to bring up in terms of that. Going back to the idea of material prejudice, just Lisa, maybe you'd like to come in here. You seem to be well versed on the phrase material prejudice in section 214. Sorry. What did the judge say about material prejudice within the meaning of that provision?
I don't have the case in front of me, Michael. What didn't I say before?
Oh, you can just reiterate. You can just, say again what you believe is necessary to prove material prejudice.
Oh, okay. Just that the test is objective, and it's to take into account the buyer's circumstances, and to look at whether there's a causal relationship between the inaccuracy in the contract and the prejudice that's occurred with the buyer, and that also that following the case that it was clear that there seems to be a consumer protection element following the case to purchasers of lots in community title schemes.
Yes, that's correct. This really leads us on to the second part of the question, and you don't need a copy of the case in front of you, but it's there on page 114 of your text. That the quotation that's taken there from the Mervac case, and just that last sentence, which is what I've targeted in that second part of problem 7. Just if you've got the textbook there in front of you, page 114, the quotation, in relation to material prejudice, a person would be, but just read the last sentence in that quotation.
Starting the evaluation.
Yes, that's right. That's correct, yeah.
The evaluation of whether any disadvantage or detriment reaches the level of material prejudice, such as to warrant cancellation of the contract, must be objectively determined in accordance with community standards.
What does that mean?
Well, that's really talking about that reasonable person test again, isn't it? What, according to how the community standards.
Which community is the judge referring to, do you think?
Oh, the community at large? Everybody?
Does that include the hooligans going to the tennis centre?
Yeah, probably.
David or Grant, any thoughts?
I got a slightly different take on it. I thought the community standards they were referring to was narrow. It wasn't the broad community, which in that case would include the hooligans. It was the like type of people in similar circumstances. What would they expect or what would they think? That to me is the community that they're referring to.
But if you read that's a nice alternative position. But if you look at the way he's phrased that, he says must be objectively determined in accordance with community standards. If he had wanted to circumscribe the community to whom he was referring there, would he have expressed it like that, or would the judge have expressed it differently?
Yeah, I think he is referring to the wider community by saying that, and I think he would have specified who the community was if he wanted to narrowly construe it.
Right. So
I think if he,
Lisa, please, yep.
That he would have qualified. Oh, sorry, I was just going to say if he didn't mean the wider community, that he probably would have qualified it.
I certainly think he means, if we can use this phrase, the community at large, okay? But if we talk about the community at large, who do we include in that?
The hooligans.
I was going to say that.
I knew you'd come back to the poor hooligans. Oh my goodness, a bit too much emphasis on that, I think. But the point is, so if that's the, I mean, let's look. There's a few reasons why I'm getting you to focus on this. But what the judge is trying to do here is to say that on the one hand, it's an objective process. It must be objectively determined. Yes. We're not wandering down this path of of just what I think because I'm a judge or whatever, right? So that's fine. That's what the framework of the law is requiring. But it's also what the community expects. It's also what the general public would expect in this situation in terms of what would amount to material prejudice. Okay, and the judge had said earlier that there's no special mystery in this phraseology or in what that means, but material does mean something substantive. Okay, and then we have to go back to the facts, of course, to work out whether what's actually happened in this case meets that standard of substantive. But that's all subject to interpretation by the judge or the court at the end of the day as well, as we know. We can't get away from that. But this idea of community standards means it's benchmarked against what the wider community would expect to amount to something that is substantially prejudicial to the seller, or to the buyer in this case. And notice here that benchmarking back to the general community then breaks down any particular influence, appropriate influence, I'm not suggesting inappropriate, that might be coming to bear because of the circumstances or the status of the individuals concerned. So this makes the interpretation actually very egalitarian if one wants to theoretically explore the nature of the interpretive process here. But the question I want to toss back is, it's all good and well, and judges and politicians too use this standard of referring to the wider public interest, and they use that phrase too, and the community interest in the community from time to time when they want to indicate that they're in touch with or connected to what is the general consensus, if you like, amongst the population about things or matters. Can we, at the end of the day, really talk about one homogenous, unified community response to these sort of matters? And who interprets that in terms of what the standard actually is? And how objective is that interpretive process then ultimately? Does someone have a question? I think Lisa, did you have a...
No, that's okay. I think it comes back to what Grant said, that it's a contract. It's black and white. It's been breached, and Mervac should be fined for wasting the court's time.
Done and dusted. Yes, that's right. That's right.
Why are we even discussing it?
Why are we even discussing it, man? And if you're out in practice...
Michael?
Grant, yes, Grant.
Is it too broad? And I'm going to sound a little bit repetitive, but isn't the community standard, or is it reasonable? To me, the community standard, similar to what Lisa is saying, but a slight variation, is that the community standard is that everyone should be entitled to have what their expectations are satisfied, particularly under contract. Now, that may be different. To try and have a homogenous community standard, if someone doesn't require wheelchair access, you're appealing to the community standards sort of common sense of goodwill that, yes, that should be there for a disabled person. To me, it falls into that category. I think the community standard is not what the community as a whole thinks individually. It's their expectations as to how it should apply to that individual, given that individual circumstances in that specific sort of event. So I still think that they can work together.
Yes, that's good. I actually think that it may not appear so on the surface, but I think there's actually a nice synergy between what Grant has said and Lisa's very practical approach. I mean, we need to be pragmatic at the end of the day, people. Of course we do. Okay, we do. That's the law needs to be pragmatic. But I think what might ultimately be, is what's being said here, is that this idea of the community standard is that and picking up on Grant's point about expectation, I think that's useful. And I think the expectation is that in this part of the world, we are all, irrespective of who we are, or our size, or our significance, or our wealth, governed by law. And that's without exception. And we accept the ruling of the umpire, which is, as we know, something that doesn't occur or doesn't happen in very many parts of the world. But so that it doesn't matter whether you're the wife of a federal magistrate or a federal judge. It doesn't matter whether you're a multi-million-dollar organisation, property developer. Everyone is subject to law and must follow the processes that the law provides. And in this case, we have a contract of sale, as Grant's pointed out, which governs the contractual rights and responsibilities of the parties. But then overlain on that, we actually have statutory obligations that have to be complied with and fulfilled. And if they aren't met, there may actually be contractual implications. For example, as in some of the provisions within the BCCM Act, if they haven't been met or complied with, then it does permit the parties to withdraw from the contract, and that can bring other consequences. So what I would say in response to this is that we do need to be pragmatic, yes, but we do need to also see that there are also more important issues at stake and in play here in terms of the tensions between both parties to this contractual relationship that involves an interest in land, and that it's affected not only by the contract but also by overarching legislation, and that's just the terrain of a conveyance. It is affected not just and governed not just by the contract of sale and the clauses, and as we'll see in subsequent topic, the special conditions that may be inserted in those clauses into that contract in addition to standard terms, but also legislation significantly that affects what parties can and can't do with each other for reasons of greater public purpose, social purpose, beyond the needs of the contracting parties. So that's really what's going on here. But at the end, we do need to have an outcome. The parties need an outcome. We had one, of course, in this case. And as a consequence of a Superior Court decision, we also get guidance as to how we should understand how to interpret this framework of law impacting upon land transactions. But also, we do need to appreciate that there are some deeper ideas and some deeper values at play here in the process. Good. That was a nice, robust discussion, people. Excellent. Very, very good. Can we move on to problem 8, please? Problem 8 taking us into this area of the relationship between the conflict between guaranteeing certainty to an individual purchaser on the one hand and the social interest in protecting cultural heritage on the other. And you've been referred there to a number of pieces of legislation. So this question is now taking us out of the minutiae of a contractual dispute between parties that is evidenced and reflected through decision like Murvac, for example, and how we navigate our way through the matrix of the provisions like in the BCCM Act and how it applies to a land transaction and so on and so forth, and how that can impact upon the contract of sale and the parties' rights and entitlements, to what arguably is a broader canvas of this interconnection or disconnect, if you like, between private interests of private landowners and the social interest that in terms of protecting cultural heritage, and how that's reflected both in terms of legislation but also possibly in terms of the relationship between legislation and the contract of sale itself. We'd like to start our reflections on problem 8. David, any thoughts to kick us off?
Yeah, I think just from just reading over the question again, and obviously it is an important thing to be able to protect cultural heritage, and I'm not really sure, how you'd balance or find a balance between, the certainty to a purchaser of land and creating that balance between protecting cultural heritage as well.
You certainly need to seek a balance. What might be, and this is for anyone really, David or the other two of you, what can we think of some going back to Lisa's point about being pragmatic, it's always very useful to come up with a practical example to help us to focus on the tension or the issue that we're trying to think about. What might be a practical example of the sort of tension that we're trying to grapple with here?
Is the Spencer case a practical example?
May well. Tell us.
Still hasn't been heard in the High Court.
Tell us about Spencer, sir.
Where a farmer who is not able or was not able to clear his land because the government enacted in compliance with, I think, the Kyoto Protocol, they basically turned a lot of farmers' properties into carbon sinks. So by prohibiting the farmers from clearing the trees to comply with their international obligation, that basically incumbents on the property. And so then when relating this back to the question, and this is where I got a bit lost with this question, is the protection. There doesn't seem to be any protection per se or balancing of the existing property owner's rights, because that can just be legislatively changed and taken away. It seems to be more the disclosure for an intending purchaser so that they're aware of it, so they can go into it eyes wide open, that there is an incumbents and they can make an informed decision as to whether they want to proceed.
Can I just press you a little bit on that penultimate point that you made? What does that, you mentioned this idea that the private property owner's rights can just be legislated away. What does that say about, and this is trespassing a little bit into land law, I suppose, but it certainly is germane to this course as well. What does that say about, the idea of indefeasibility of title of landowners?
Indefeasibility of title only exists between private property owners. It doesn't exist when the legislature gets involved, because the legislature can simply override it and overturn it.
So does that mean that...
I don't see how...
Sorry, go on. Yep.
I don't think there is indefeasibility when it comes to the legislature.
So does that mean that all this huge amount of law that we have and debate that we have about the sanctity, almost the sanctity, I think it's put in those terms, of indefeasibility of title and the quality of ownership that it confers and so forth is basically a bit of a myth? Can we put it as high as that?
If no one else is going to jump in, I would say yes, but to qualify it, the government still has to have a purpose behind why they're going to do it. So I don't think that every title is at risk, but certainly to me it is a myth in terms of real property ownership, because land can be resumed. As you know, it becomes a separate argument about fair compensation, etc. But
just on that
certainly, I think
just on that point about fair compensation, state governments and local governments are under no obligation to give fair compensation, by the way, and there's no injunctive provisions anywhere that suggest that they need to. And with respect to the Commonwealth, it's only required to give compensation when it acquires property on just terms, but when it acquires property, and it must do so on just terms, but only then, of course, in the context of 5131 of the Constitution, which means that it's enacting a law with respect thereto in relation to the acquisition of the property. So there's a lot of qualifiers there in terms of, you know, the landowner actually getting or being required to get some sort of compensation for being, if you like, in quotes, dispossessed of their land or affected in some way by government action or activity. Yeah.
That's the underlying point of the Spencer case, I think, isn't it? That they're challenging on the basis that, okay, the government hasn't acquired the land, but by placing an encumbrance on it, they've heavily restricted the use of it, which their interpretation is that it's the same thing.
Yeah, yeah. But see, this is a misconception by property owners because they have swallowed the myth, the myth, what I call the myth pill, that they think that because they're a landowner, they are sacrosanct from impact, when the truth of the matter is, when push comes to shove, even though private landowners don't like it, social and public purpose, as determined by the government of the day in a democracy, takes priority. So that, and very well, you know, explained in terms of the Spencer case, Grant, in terms of the, you know, the sink things in the land and these sorts of things with regard to climate change policy. The other thing too, which is interesting in Queensland, it hasn't happened in all the jurisdictions, but certainly in Queensland, is that those issues with regard to climate impact and government proposals and implementations with regard to that has been specifically incorporated as an exception to indefeasibility within the Land Title Act, the Torrens Act in Queensland. So that's, you know, and that we don't have hardly any, if any, case law on that in terms of, you know, that how we understand the reach of those provisions within the LTA. But coming back to matters of heritage, you know, the things that I've referred to there is I've referred to both international legal instruments and also local Queensland legislation. I mean, how do we see a correlation between, for example, you know, a contract of sale at the very local level between a seller and a buyer and the potential impact of, you know, an international convention like the Convention Concerning the Protection of World Cultural and Natural Heritage? I mean, for example, there's been, you know, what about, you know, in some areas in Queensland, you know, the Daintree rainforest, for instance. There's lots of other areas, areas along the coastal fringe. How do we understand the balance to be struck here? Which takes priority? Is one necessarily? Lisa's going. Okay, see you, Lisa. Bye. Thanks for joining. Your contributions valued as ever. What balance? I mean, what I'm trying to get you to think about is what balance should we be striking at the end of the day?
Now you've returned back to the subjective conversation.
Have I revealed my cards too fully at this stage? Look, I mean, it's well spotted, Grant. Well spotted. It's again this balance, isn't it? That's the truth. It's again this balancing act, so that it's neither never. It's neither never all of one and all of the other, but there has to be an accommodation. Okay, so that the contract of sale is the document. It is the framework that is moving the interest in the land from one party to another, which finally gets to the buyer when we get to completion. Along the way, and you pointed this out earlier, Grant, along the way, the buyer needs to be aware of a range of things that can affect the interest that they're seeking to acquire through this contract. David's on his way too. Okay, see you later, David. Thanks for joining and thanks for your contributions. Just you and I, Grant. So the things that can impact, as we've indicated previously, are not only to be found within the four corners of the contract, but this broad array of legislation that can also impact upon what the buyer can do with their land ultimately, can do with their interest in this parcel of land or lot, as the nomenclature in Queensland uses for what's being acquired. And that's something that they are entitled to be aware of, right? But they must understand that the government of the day can pass legislation, has passed legislation that will be about protecting things and preserving things in the environment, in the community, in the space at large over which they have jurisdiction, which are broader and more significant than their private interest in this lot. But we're not saying that we're totally negating the recognition of the interest that you have in the lot, but that those other interests may supervene your interest ultimately or in some way to protect these other matters. This part of the balancing act we're trying to achieve at the end of the day. And in terms of the theme within this topic of seller disclosure, that these are matters that the buyer is entitled to be aware of as a part of the process. And that's as it should be. Comments, Grant? You're the last one standing.
Not per se, because I think on the heritage subject, really the message that I got out of that, because to me it's subjective and it's debatable as to why governments agree or enact things. They often have their own agenda, whatever their political will is for doing something. So bringing it down to the black letter of the law, it's really about the buyer knowing about encumbrances so that they can make an informed decision as to whether to proceed or not. And if this is the ethics argument that comes into it, if the seller does not disclose what they should disclose, then the buyer has a right to terminate.
But don't think this is only a debate that exists in these contexts, for example, like heritage. These debates and these jockeying of positions exist just as much, for example, in reforms to the BCCM Act, where you've got property developers lobbying the government hard to make changes that in a sense, prefer their position in terms of what they're trying to do. You've got other interests saying, well, we have to find some balance here in terms of property development. And then you've got consumer protection interests of those who are ultimately going to be consumers of services and acquirers of land in the process. So that is a backdrop for the development of all what, in your terminology, becomes black letter law. And how it gets applied and how we understand it at the end of the day, we need to appreciate that, okay? I mean, at the end, when one moves out there into the world of practice, if one is, for example, involved in land transactions or conveyances, then, these sort of issues don't necessarily present as the forefront within transactions all the time. Lisa's point earlier about, well, this is let's be pragmatic, practical, get on and do it. Yes, of course, clients want you to be like that, but don't assume that you will necessarily always be representing a private landowner who is a purchaser. You may well be representing, for example, at some point, the Conservation Foundation. You may well be representing the interests of the state of Queensland, the government of Queensland. You may well be representing who knows what interests, because every entity and every grouping that has a legal status is entitled to representation and a voice within our pluralistic liberal community. And very often they will seek to advocate through legal process their rights and entitlements. So one never knows what sort of disputes one can be involved in at the end of the day. And we need to see that broad canvas upon which law operates and functions. All right, just quickly, just to follow, wrap up. So we've been focusing here on the seller's obligations, and both in terms of existing lots and proposed lots. We're looking at the topic generally looks at not only houses and land contracts, but there's also discussion there about commercial contracts as well, not so much focused on in the two problems, but be aware of that debate and that discussion about commercial contracts. The relationship between the provisions of the contract of sale and this overarching legislation, both more specifically directed towards seller disclosure, like the BCCM Act on the one hand, and other types of legislation that can impact upon the seller disclosure requirements, like matters of cultural heritage and so on and so forth, need to also be understood. And then in the end, we're looking at how do we strike the best balance between the private interests of land holders and lot and proposed lot acquirers through purchase, and social and public interests, and how these are protected and underpinned by the different legal structures and framework that governs this process. The contract of sale on the one hand, and the array of legislation and the body of case law that's interpreting both the provisions of the contract of sale and the array of legislation on the other, to come to some accommodation and understanding of how we get that balance right in the end. All right. Grant, question?
The context of this is relating to a buyer and a buyer and a seller. What about in terms of leases? If a property is being leased, is there a duty on the leaser in that case to disclose restrictions on the property, including heritage restrictions?
Well, of course, the lessor is the owner, and the lessee taking a lesser interest in the property, but an interest in land nonetheless. And we will see in land law, when we look at a couple of weeks' time, we'll be looking at leases, and I know you're taking land law. And subsequently, in another topic, we do look specifically in this course at a particular type of lease that's more relevant in this context, and that's retail shop leases. But yes, there can be obligations, of course, between lessor and lessee in terms of things that need to be made known in terms of intended use. The area, in terms of leases, we need to differentiate the general law framework from specific legislative provisions that have been created for specific types of leases. So we have the general law framework, which tends to govern commercial leases. We have specific, and this is in Queensland, but also in other parts of Australia, and I know you're not in Queensland, so it's important to make that point for you, that there's legislation in place in Queensland and also in New South Wales governing retail leases, and in Queensland it's called the Retail Shop Leases Act 1994. In New South Wales it's the Retail Leases legislation. And there's also specific legislation governing residential tenancies. Okay, and that tends to provide its own framework of determining the rights and obligations between lessor and lessee, or landlord and tenant, depending on what type of lease or rental agreement you're talking about. But the framework of the general law governing general leases, and mostly today we refer to those commercial leases situations, yes, there can be specifications with that. Have a look at the, once it's up there, the material on leases in land law, and then also the discussion in this course with respect to the specific type of lease, the retail shop lease in particular. So, yeah, a good point. Good point.
Thank you.
All right, I'll bring it to a close there. I just might note before I do that, of course, the quiz will be taking place next week. The first quiz covering, I think I've said the first three. Was it the first three topics? I think in the course, so that'll be opened up next week within the specified window. You've got the instructions and information already about that, we'll proceed next week, and hopefully this timing is better. I've certainly had three out of four, and I don't think, as I said, Tingen can actually come, so that's good. Yeah, anything final, Grant?
No, good from here. Thank you.
Good from here. Good. Okay. Well, bye for now, and we'll see you in next class.
Thank you, Michael.
Bye.
Bye.